Thank you for joining us. So today we'll be discussing the topics of non-molestation orders and occupation orders. We have two members of our family law team with us today, Acton and Ellie, who are going to be giving advice and answering your questions. We'll also be taking questions from the chat box, so feel free to leave us your questions below. Our team will answer them for you towards the end of the Q&A. So Acton and Ellie, can you introduce yourselves and start off, please?
Hi, good morning. Good afternoon. I'm Duncan Alfonso. I'm a family solicitor at Duncan Lewis here in Milton Keynes. I'm with Ellie.
My name's Ellie Williamson. I'm a trainee solicitor at Duncan Lewis and I work in the Milton Keynes office.
Welcome everyone. Today we're going to talk about non-molestation orders and occupation orders, and there's a couple of questions that are quite, very, very relevant to anyone willing or who seeks to apply for perhaps a non-molestation order or an occupation order. One of the most important sort of questions is, what does a non-molestation order stop someone from doing? Depending on your circumstances, a non-molestation order typically prevents the person it is made against, from using or threatening violence against you, intimidating, pestering, or harassing you. It can also stop them from instructing, encouraging, or in any other way suggesting that any other person should do those things either. This can apply to contacting you over the phone or even via social media. On occasion, there are zonal orders which are attached to a non-mol. It can potentially stop people from coming to places such as your home, street, or even workplace. The order can apply to you, to your children, as long as there is a good reason. So it's always on a case-by-case basis, and ultimately it's up to the court to decide what sort of order is most appropriate and whether your circumstances, whether your situation sort of demands the type of non-mol or zonal order or the protection that you are seeking.
Also, in terms of occupation orders, so an occupation order usually stops someone from living in a certain property, and that's even if their name is on the mortgage or on the tenancy. This order can be made when two people live together, but maybe one person doesn't feel safe. For example, if one person is being abusive, making someone else, putting them in danger. So it can basically mean that they are separated, so they don't live together anymore, hence removing the harm, hopefully. It can, sometimes instead of removing someone from the property entirely, it can just stop them from going to certain parts of the property. So, for example, if there's, certain rooms in the house where the applicant wants to go, where they don't want the respondent to also go, they can apply for the occupation order to be for the specific rooms in the house. This is different from a non-molestation order because it deals with who lives in a property rather than what that person can or can't do in terms of being violent towards someone or pestering or harassing them.
So once let's say for, in a hypothetical situation, we've already got the non-molestation order. The next question is, what happens if someone breaches that non-molestation order? Non-molestation orders and breaching them essentially is a criminal offence, and the person who has breached the non-mol order can be arrested. It is usually punishable by up to 5 years in prison, or perhaps sometimes even a fine, sometimes it's both. But breaching a non-molestation order is a serious offence and is also a criminal offence. So it does carry quite a lot of weight when you have some, a non-molestation order in place.
So in terms of an occupation order instead, a lot of people often wonder if you can be arrested for breaching an occupation order. With occupation orders, it's not the same. So as it's on its own, you couldn't be arrested for breaching an occupation order. unless there's a power of arrest attached to it by the judge when they make the order. So the power of arrest is the thing that lets the police arrest someone for the breach. If the power of arrest isn't attached to the occupation order, then the police can't arrest the person for the breach.
So another important question most of the time is who can apply for a non-molestation order and who can you apply it against? And this also applies to occupation orders as well. The Family Law Act 1996 basically governs a person's eligibility for non-molestation orders. The short version is that you can apply for a non-molestation order against an associated person. Most of the time, non-molestation orders are used when parties are in or were previously perhaps in a relationship. An associated person usually means a spouse, an ex-partner, or any other family member. However, these are not just limited to relationships. Children can also apply for non-molestation order against a parent, as can people in other relationships. The full list of associated persons, as defined by the Family Law Act, is as follows: people who have been married or civil partners, or people who have agreed to marry or enter into a civil partnership, people who have cohabited, people who have lived in the same family household, people who have had an intimate relationship for a long time, people who are parties in the same family proceedings, and even people who have shared parental duties. So this is like a list of people covered under the associated persons defined by the Family Law Act.
In terms of legal aid funding, this is a bit of a hot topic around injunctive orders, so protective orders like these. So can I get legal aid funding for a non-molestation order or an occupation order? So the short answer is yes. It depends obviously on your financial circumstances. So to get legal aid, you usually need to show essentially that you can't afford to pay for your legal costs, and that your problem is serious. So usually you need to give details to the person helping make your application to the legal aid agency you need to give them evidence of your income, any benefits that you receive, any savings that you have, if you have a financial interest in any property, and also that applies for if you've got a partner as well. The person doing your application will need to have a look at their finances as well, because they're treated as linked essentially.
Another question a lot of people have is when you make the application for a normal occupation order, will your ex-partner, will the person you made the application against, will they be notified that you've made an application? Now, this depends on two situations. One is whether you've made the application with notice or without notice. With notice basically means that the other person is going to get notice of the application. If you make a without notice application, in such a situation, you can sort of stop the other person getting a copy of it at that point in time until you have perhaps a hearing, and the court will may decide that, we need to give notice of this application. Ultimately, you're still at the mercy of the court. If you still make a without notice application, sometimes the court may consider, this may not be appropriate, we need to give notice, and at that point in time, even though you made the without notice application, the person dealing with the application from the court, perhaps the judge, may feel like, this is not appropriate for a without notice application, and notice is necessary. However, a without notice application will be successful where the court feels it is just and convenient to do so, and especially if it's very necessary. For example, it may be where one party is perhaps at a risk of significant and immediate harm, and giving notice of the application may cause the perpetrator to act out or harm the applicant, or even make their behavior unpredictable. So in this sort of situation, immediate intervention from the court is absolutely necessary. It tends to happen where there are threats against someone's life, perhaps, or even if the person they are seeking protection from is maybe a convict, or he may be out on bail, but his bail conditions have lapsed, or he just doesn't follow up, have any regard for the law. So in these type of situations, if they try to contact you, or you feel like your life is going to be at harm, you can make a without notice application. And when you make it without notice application, the other person will not get notice of it until at some point the court or judge decides that we need to give notice. Notice is necessary.
Also, another question that's often asked is whether a non-molestation order can cover just the person that's applying, or whether it can apply for their children as well. Sometimes people are applying for non-molestation orders in respect to, potentially the other parent to their children, just for example. So it can apply for the adult person that's applying, and also their children in certain circumstances. If you feel as though the person that you're applying for the order against is also posing a risk of harm, or has harmed the children involved as well, then you can ask for the order to cover both yourself and the children. You would just need to justify why it needs to cover the children as well when it's before the judge.
When you make the application, or once the order, say non application order is granted, another question that arises is how long do these orders last? It depends on the case, really. Some cases have non-occupation orders that last 3 months, some last 6 months, some last a year, sometimes even longer. Ultimately, it depends on the case, and it depends on what's the most appropriate protections you should get. If the incidents are so serious and the risk is so serious, then the normal might be for a significantly long period of time. If the risk to you is less, perhaps then the court might say, well, 3 months should be sufficient. It entirely depends on each case. Each case is different. Each case circumstances are different. Also, in certain situations, you can also reapply if the say normal is coming to an end. If you don't feel that, if you feel like maybe this is not going to be sufficient protection, or you're still worried or still scared, you can always reapply. Like I said, how long does non-molestation occupation order last? It depends on case-by-case basis, and it varies.
So, final question is around undertakings. So, a lot of the time, people hear about undertakings and they don't really understand what that means. So, an undertaking is separate from a court order, like a non-molestation order or an occupation order. An undertaking is essentially a promise that you've made to the court, and it's recorded, it's in writing. And it's essentially, if someone makes an undertaking to do things like not intimidate, pester, harass, or be violent towards someone, it's not quite as severe as a court order stopping them from doing it, but it is a promise. So if you undertake not to do something and then you do that, you've breached the undertaking, then the person that you've done that towards can make an application to the court, because the person who has breached it wouldn't be able to be arrested just for the act of breaching the undertaking, because it's not a criminal offence. So that's what undertakings mean. That's all the questions that we had ready to answer. I know that we'll leave a minute or two to wait and see if anybody has any questions, and then we'll end it there.
So it looks like we don't have any more questions at the moment. So thank you to everyone who joined the Q&A today, and thank you so much to Acton and Ellie for their time and for sharing your very valuable insights. But if anyone has any further questions or they need more, you can contact Duncan Lewis directly at the number that I put into the chat box, and you can also email Acton and Ellie directly. I will also put the in the chat box. We've also recorded this live Q&A today, so everyone will be able to rewatch it later on. But thank you to all for joining us today, and we found this session helpful, and have a great day. Thanks.
Thank you.
Thank you. Bye.